Hello, welcome to this edition of the Outer Temple Chambers Spinal Injuries Vlog. Ian and I are going to be speaking today about care claims in spinal injuries cases.
Jonathan will be starting off and then I will be concluding the vlog. Should you have any questions for us, we will have our emails at the end of the slides, so please feel free to get in contact with us if you have any inquiries.
Thank you, Ian. Well, we divided it up that I'm going to deal with the first two areas on the slide here. So looking briefly at principles for the assessment of future care and then double up care. Ian is then going to follow on looking at care in hospital and pre-existing conditions, all in the context of spinal injury claims. We thought that these would be useful topics to cover because, as you'll all be well aware, care is often by far the largest head of loss and can give rise to a wide range of issues. We're trying to focus on some of the issues which certainly in our practice we encounter frequently and which can often have a significant impact on the value of the claim. So let's start with the first of those topics, principles for the assessment of future care. Now, this slide is in no way intended to cast aspersions on our judiciary, but it is supposed to reflect, or intended to reflect, the fact that the outcome of these sorts of issues, particularly in relation to future care, can be uncertain. And of course, as in our role as advising our clients, we are trying always to anticipate how a judge is likely to decide the issues in relation to future care, amongst other things, in our cases. And so it's helpful, I think, to just take a step back and look at some of the principles that apply in relation to future care. If we start by going back to basics, as you'll all be well aware, the key test for assessing the amount of damages recoverable for future care is that the claimant is entitled to recover what is required to meet reasonable needs for care resulting from his or her injuries. But one of the issues that frequently arises is in relation to competing care regimes. And it's with that in mind in particular that I want to spend a little bit of time looking at the case law on future care and the principles applicable to future care in this context. There are two leading authorities in the area, quite old now, Realis and Mitchell in 1984 and Sarden and Lodge in 2004, both of them Court of Appeal decisions. And I'm not going to dwell on those. Rather, what I'm going to look at is a number of first instance decisions more recently, which have applied the principles established in those two cases, and then look at how one might go about applying them in the sorts of cases that we commonly encounter. Starting first of all with Massey and Tameside, and this was a case where there were competing care regimes being advanced by the parties in relation to future care. One of the issues being whether the claimant should have an agency carer or a directly employed carer, and also issues between whether the care should be provided at home during the daytime or at a care centre, day centre. And it's helpful to see what Mr. Justice Tier said in resolving those differences of opinion. As he put it, I sought to apply the principles stated and explained in Sarden and Lodge, which were in turn derived from Realis and Mitchell. Those are the two Court of Appeal cases I mentioned just now, to the effect that the claimant was entitled to the reasonable cost of caring for him in the manner chosen by him or by those with responsibility for the claimant, so long as that choice was reasonable. So that's the touchstone. A lesser sum would only be payable if the claimant's choice of care was unreasonable and another form of care was reasonable. And then set out the correct question to be addressed in relation to care was what is required to meet the claimant's reasonable needs. So setting out in quite clear terms there the fact that it's the question is what is reasonable, and it doesn't have to be for the claimant simply to advance a case which was economically the most attractive. And the point was picked up again a few years later by Mr. Justice Cranston in a case called Smith and LC Window Fashions Limited. And again, there were competing cases about the future care regime between the parties. And Mr. Justice Cranston, really returning to the theme that had been advanced in the Massey case we just looked at, said this: "The question I must address is what is required for the claimant's reasonable needs. So long as the proposals of his professional advisors are reasonable, he is entitled to the reasonable costs of effecting them. There's no need to approve the least cost option unless any other option would be unreasonable." And certainly looking at those two cases, and particularly the extracts that we've just been through, that suggests certainly a broadly favourable approach from the claimant's perspective, because it appears to suggest anyway that the claimant's care regime, or the claim rather, should prevail unless the defendant can show that that care regime is unreasonable. And that may often be, on the evidence, a relatively high hurdle for defendants to overcome. Just add a note of caution here, because necessarily this is an overview of these issues. They are somewhat more nuanced, and if you have a claim or a case with a claim for future care where these issues arise, you might find it helpful to look at the discussion which is set out in rather more detail in the commentary and the two references I've set out on this slide. I think in terms of a practical approach to the quantification of future care claims, a three-stage approach is often appropriate. And I've set it out here on the slide, and I'll just run through that in a little bit more detail. Firstly, the starting point is what are the claimant's future care needs? And that clearly is something that will be established from the lay and the expert evidence, including from the medical experts, based on the claimant's present condition and indeed any changes in the future based on the prognosis. The second stage then is to look to see whether the claimant's chosen model of care is reasonable, and the sorts of issues that we've just been looking at may come into play in relation to the second stage, particularly where, as quite often happens, you've got a dispute about the type of care regime, for example, agency care versus directly employed carers, or even sometimes private care at home versus residential. And then thirdly, once the model of care has been established, the reasonable model of care, what are the reasonable costs of meeting the claimant's future care needs? And then one is considering the amount of hours required, hourly rates and so forth, with particular reference, of course, to the care experts' evidence. That's a relatively quick run through some of the principles that apply in relation to future care. And I'm going to turn then to the second topic, which is double up care. That, of course, is frequently a contentious area in catastrophic injury cases because of the increase in value that flows if it is found that a claimant requires two carers, particularly if it's two carers throughout the day, as is often recommended by claimants' care experts in these sorts of cases. The issue, as many of you will no doubt be aware from these cases, turns primarily on whether it's reasonable to have carers present throughout the day, or whether, as defendants' care experts will normally advocate, a second carer only present at certain times of day. And I thought it might be helpful to look at some of the cases where these issues have been fought out, and look at what the judges say, because they give just an indication, at least, of how the courts may approach this issue and the particular factors that have played into or have been relevant to the judge's decision on the point. I make the obvious caveat that these are only first instance decisions and ultimately turn on their own facts. But as I say, hopefully they will give some guidance to how courts may approach the cases as they arise in the future. So if we start with the case of A and B Hospitals NHS Trust, the claimant was severely disabled due to a birth injury and required carers for safe transfers by hoist. And there was a need for transfers several times a day, particularly at unpredictable times, in part at least because of the claimant's incontinence. The claimant's care expert, therefore advanced a regime based on full double-up care throughout the day. The defendant's expert was limiting the double-up care to 4 hours per day, so a fairly familiar scenario. And what Mr. Justice Lloyd-Jones, as he then was, said in determining this issue is set out on the slide. I consider that any attempt to reduce the number of transfers would seriously damage A's quality of life and would therefore be unreasonable. It'll be necessary for A to be transferred for his health and comfort throughout each day. And whereas certain transfers can be planned to take place at particular times, that won't always be the case. And hence it makes it necessary that 2 carers should be available throughout the day so that transfers can be carried out immediately as and when required. And I think interesting to take away from that short extract, the focus on the quality of life of the claimant. That, it seems, was the test or the touchstone that Mr. Justice Lloyd-Jones had in mind when determining the issue in favour of the claimant. The second case is Massey, which we touched on just now in relation to the previous topic. And again, a broadly similar issue arose where the claimant was contending for full double-up care throughout the day because of the unpredictable nature of transfers. And the defendant's expert put forward a slightly different care regime, which was 1 residential carer and 1 agency carer at certain times of the day. And again, the issue was decided in the claimant's favour, and it's helpful just to see from the judgment of Mr. Justice Tier what factors it seems were such that the claimant's case prevailed on the facts in Massey. As you can see from the extract, what Mr. Justice Tier said is it's very difficult to see why, in principle, a preference to lead as normal a life as possible could be said to be other than reasonable. The brain injury that Joseph suffered at birth has deprived him of that independence, freedom of choice, autonomy, and mobility which non-disabled people have and take for granted. And the care regime advised by Mrs. Dakin, who is the claimant's care expert, aims to give him that independence, freedom of choice, autonomy, and mobility. And making clear with that example how he will benefit. And so again, the judge there was influenced by issues such as independence, freedom of choice, and indeed, as we can see from the remainder of the passage, quality of life. As he refers to the care regime that Mrs. Bingham, who was the defendant's care expert, advanced, and the fact that there will be periods when transfers couldn't be effected, the judge thought that was unreasonable, and that he was not satisfied that, as submitted by the defendant's counsel, they would only have a limited impact on the quality of Joseph's life. So where the restriction would have a significant impact on the quality of life, one can expect a judge to be favourable to a claimant. Again, broadly similar issues arose in the case of Wakeling and McDonough, which I just include as a further example and a slightly different approach that in terms of the reasoning adopted by the judge, His Honour Judge Mackey, in that case. Just looking at the extract there, particularly at the bottom of the page, where the defendant's argument was along the lines of there's going to be a lot of time when the second carer is sitting around doing nothing, and that will be a waste of resources, a waste of funds. And what the judge said, as one can see from the extract, is that potential waste of resource is something the defendant should bear, given the manifest unfairness of him having to save money by imposing unnecessary restrictions on his enjoyment of a very limited life. So again, the balance in that case was in favour, by reference to quality of life issues, in favour of having full double up care. Now, you might think from those three cases that it's all one way, but that's not the case, and it's helpful to look at a couple of cases where the courts have decided the issue rather differently. So I start with the case of Farrugia, a decision of Mr. Justice Jay, who, with his usual, in his usual incisive way, and again, this was a case where the claimant had suffered a severe injury and required two carers for safe transfers by hoist, and it was said that that need for transfers was unpredictable during the day, and the claimant had advanced therefore a full double up care regime, whereas the defendant's expert was seeking to limit it, amongst other things, by saying that family members could take over in the evening. Mr. Justice Jay set out his reasoning on that issue in this passage, saying that there's a difficult and sensitive balance between respecting the personal autonomy of Jack, the claimant, and other members of his family, paying proper regard to what is likely to happen in practice, and avoiding the presence of a supernumerary carer to the extent appropriate. That was the argument that was being run in this case, as it was in some of the other cases we've just looked at. I don't accept Mrs. Sargent, who was the claimant's care expert's evidence that Jack should in effect be free to do whatever he wishes at the spur of the moment. I don't consider that Jack's personal autonomy is overridden, or the dictates of spontaneity are unreasonably quelled by providing for a regime which presupposes a modest degree of pre-planning and organisation. This, after all, reflects the realities of ordinary life. So Mr. Justice Jay there was saying that there is a balance to be struck, and certainly if the claimant's needs can be met with a modest degree of pre-planning and organisation, as he put it, then some restriction on the provision of double up care is appropriate. It's worth bearing in mind that actually on the facts there, the restriction was really quite limited. The double up care was allowed throughout the day, or throughout the daytime, and it was only in the evenings when family members were expected to provide care for which they will be compensated as gratuitous carers. So that's a move, if you like, a little bit away, or redresses the balance somewhat away from those, the three initial cases we looked at. And then finally, helpful to look at the case of Davis and Bradshaw, not strictly a double up care case, but I think the reasoning is such that it might apply in that context as well. The circumstances in Davis were that the claimant was an incomplete tetraplegic following a road traffic accident and was able to walk short distances, but had a risk of falls, and claimed for a live-in carer on the basis, amongst other things, that it was necessary to provide assistance in getting him up after falls. So yes, Mr. Justice Wilkie gave his reasons as follows. He said, whilst I understand the clinical judgment made by Mr. Jamil, who is the claimant's care expert, medical expert in that case, concerning the inadvisability of persons with the claimant's injuries trying to walk for the sake of it, in my judgment, he fails sufficiently to take account of the contribution which a person's sense of worth and well-being makes to their functioning, and the extent to which physical activity contributing to a general state of fitness and stamina has a positive impact upon their functioning. And his view was that those considerations, the judge's view was those considerations override the clinical risks that Mr. Jamil had identified, and for that reason found that it was not reasonable for a living carer to be present throughout the day. And that just demonstrates how on the particular facts of the case, the judgment or the need for permanent care throughout the day could not be justified there. So that concludes my part of the talk, and I'm going to hand over now to Ian.
Thank you, Jonathan. The first issue I'm looking at is claims in respect of care provided by family whilst the claimant is in hospital or another medical care facility. It may be considered that a claimant should not be entitled to recover damages for gratuitous care during the period when the claimant is in hospital receiving treatment from trained professionals. However, compensation for such care provided will be recoverable, provided that it is an aid to the claimant's recovery rather than facilitating ordinary social contact, which would have occurred in any event. Such an example can be found in the unreported decision of the Court of Appeal in Havenhand and Jeffrey. An issue on appeal was whether or not the award of damages for care provided by the claimant's family whilst he was in hospital was recoverable or not. At first instance, 400 hours of gratuitous care had been allowed, which was reduced to 100 hours upon appeal. It can be inferred from the judgment of Lord Justice Beldam that a physical aspect was required for the care to be recoverable, but mere companionship was less likely to be recoverable. Mr. Justice Langstaff, in the case of Warrilow and Norwich Hospitals NHS Trust, considered this issue further and rejected an argument that Havenhand laid down any principle that companionship cannot amount to care. Mr. Justice Langstaff distinguished the facts from Havenhand, which had involved an elderly lady who had had many visitors, arguably in any event, with a situation where a claimant reasonably required companionship for psychological or psychiatric stability. In such cases, such care may be recoverable, provided that the friend or relative would not otherwise have done a similar act. In the words of Mr. Justice Langstaff, care is not only a physical labour. Time has its cost, and if that time is devoted, which would not otherwise be, and which meets the reasonable need of an injured party, it deserves recompense. One would have thought that that would have been clear enough to end the debate, but alas, no. Two judgments followed that muddied the waters a little. First, there is Tagg. The claimant, who had suffered an undetected perforation of her bowel during surgery, required care. The claimant's family had visited her in hospital to provide emotional support and physical care. The defendant had allowed for a physical care regime, but argued that the provision of companionship was not recoverable. The court accepted the defendant's submissions, despite there being no reference to either Warrilow or Havenhand in the claimant's submissions. The next authority is that of a decision of Mr. Justice Underhill in the case of Huntley and Simmons. In this case, the claimant suffered injuries following a road traffic accident and was in a coma for some 42 days. Some of the care claimed was whilst the claimant was in the coma, and some after that. The court did refer to Havenhand in this instance, but went on to disallow the claim in its entirety. Normal hospital visits were deemed to be irrecoverable. However, when you read the judgment, it seems that the real reason that the care was disallowed was a lack of evidence to support the concept that the care went beyond mere companionship. The recent authority of Welsh and Walsall Healthcare, a decision of Mrs. Justice Yip, seems to have resolved the matter. This is a clinical negligence claim, and there was a dispute about gratuitous care. The court was referred to both Huntley and Warrilow and endorsed the approach in Warrilow, citing from paragraph 159 of the judgment, which makes it clear that companionship can amount to care. The question is whether it is an aid to recovery as opposed to ordinary social contact. It has to be time which would not otherwise have been devoted and meets the reasonable needs of the injured party. And we can see there an important aspect in the slide, particularly in aspects where there is a psychological or psychiatric aspect, where a person is, for instance, in danger of harming herself or in danger of slipping into deeper and chronic depression. The fact of companionship may be importantly therapeutic and an essential part of the care. The following practice points arise. Not overlooking this element of the claim, which, if there is a long recovery period in hospital or another care facility, may be a substantial aspect of the care claim. Bedside care in the form of companionship can be recoverable, but it's important to emphasise the value of that companionship following the endorsement of Warrilow in the case of Welsh. And also a lesson from Huntley. It's important that the care experts and the witness evidence provides solid evidence for the purpose of the care if it is at the level of companionship. Moving on to the topic of pre-existing conditions and how to take into account of these. Intuitively, you might have thought that this exercise involves a simple comparison of pre and post-accident needs. So if you previously had a claimant that required 4 hours a day, and after he required 10, you could claim for 6 hours, right? Well, the picture isn't quite that simple. The first case I would like to discuss is that of Rennie and University Hospital of North Staffordshire NHS Trust. The claimant in that case, at the age of 61, contracted a spinal cord condition that had left her paralysed from the mid-thoracic level down. Whilst hospitalised, she developed a number of deep pressure sores and other problems as a result of the defendant's negligence. And a summary of the pre- and post-accident needs are set out on the slide. At first instance, Mr. Justice Foskett had decided that the negligence had caused the whole of the claimant's need for commercial care and made no deduction in respect of prior needs. His decision was overturned on appeal. The way the Court of Appeal approached it was to say that the essential question was one of causation. What is it that the negligence can be said to have caused? The court distinguished two types of cases. There were those cases where the claimant's needs were quantitatively changed, even if they substantially or significantly increase, but effectively it's the case of more of the same. In those sort of cases, the defendant's negligence only caused the additional need, not the underlying one. The court said that there are then other types of cases where the negligence makes a qualitative difference. In those sorts of cases, the needs are no longer the same type. In that kind of case, the negligence has caused the whole of the need in its different form. So in those sorts of cases, there is effectively no need for any form of deduction. However, unhelpfully, the court did not provide clear indications of what would amount to a qualitative or quantitative difference. And it may well be that this will become fruitful areas for debate in future litigation. However, there was some hint from the Court of Appeal at paragraph 25 of the judgment. The fact that the quality of life of the claimant was markedly worse than it would have been but for the negligence says nothing about whether the care she needs now is qualitatively or quantitatively different. In this case, there was no finding by the first instance judge that the carers required post-negligence required special skills not required by those who satisfied her pre-existing needs. As an addendum to this point, there may be cases that fall outside the Rennie duality, qualitative and quantitative differences. The case of XP is an example. This is a case which involved two car accidents, one after the other. The claimant suffered an injury following the first accident in 2011, which caused traumatic miscarriage and developed PTSD. In 2013, suffered a further accident and exacerbated her pre-existing PTSD. One of the issues was around the apportionment between the two defendants. Rennie was considered, but distinguished. The court didn't feel it was possible to separate neatly the effects of the two accidents. It felt the case felt better in the Rahman mould. That was also the case involving two separate incidents where the courts had concluded somewhat poetically that the effects of the two incidents were entwined around each other like ivy strands around a tree. The court applied the test in Rahman, set out here in the slide, which cautions against freezing the concept of causation into constricting rules. The question is about arriving at the just conclusion, and a broad brush approach can be considered. In XP, it was considered that there ought to be a 75-25 split between the causative potency of the two incidents. The short point to bear in mind is it a case which falls within the Rennie scenarios? And if so, which side? And on which side currently, based on the judgment in Rennie, may be unclear. Or is this an XP type of case where Rahman may be applied? And that concludes our vlog today. As Jonathan indicated earlier, we've got our email addresses there. And should you have any questions or queries about anything we've discussed, please feel free to get in contact with us.